Hi guys, this is Latasha Woods. In this presentation, I will be showing you all my research on Mr. Arthur Wayne Henry, who is an attorney who was currently suspended for violating the rules of ethics that were implemented by the Supreme Court of Tennessee, who created the Board of Professional Responsibility. My research will be covering Arthur Wayne Henry versus the Board of Professional Responsibility. The summary of the relevant facts to this case, basically this first instance where Mr. Henry accepted a settlement offer without advising his clients. There was a $5,000 settlement check for which he did not inform his client. Although the settlement check was never cashed, Mr. Henry did not respond to a show cause order requiring him to show cause why an order of compromise and settlement had not been entered, and this was according to a release information letter written by the board. Mr. Henry also did not pursue a post-divorce matter or adequately communicate with his client. For this particular instance, this is the one that really baffled me a lot. Mr. Henry had taken client funds and used them for his own personal benefits, and this was for the estate of Miss Cassie B. Leonard. According to an affidavit, Mr. Henry reported to Judge Rex Dale on April 17th of this year that he had taken funds from one of his clients and used it for his own personal benefits. The estate of Cassie Leonard was a probate case opened on November 10th, 2008. This particular case was involving a reimbursement claim of $82,905.31 made by TennCare. The plan was to sell some real estate to pay off the administrative expenses, and the rest was to be paid to TennCare. According to the affidavit that I read on NewsHerb website, from my research, $25,000 was sold for the real estate. The administrative fees were $2,337, and there was also an executor fee of $1,500. There was a hearing to close the estate, which was set on April the 17th of this year, and at that time, Mr. Henry admitted to taking the remaining funds. There is no exact total for the amount that Mr. Henry took according to my research, but it is estimated to be between, $21,000 to $22,000. Wow. Those funds were supposed to went to TennCare. I am totally shocked that this man was not disbarred. The punishment that was imposed for Mr. Henry. Basically, on April 30th of this year, he was suspended from practicing law for 1 year and 1 day. Mr. Henry was to be evaluated by the Tennessee Lawyers Assistance Program as well as attend 6 hours of continuing legal education and law practice management. Mr. Henry must obtain professional liability insurance, and he must pay the board's costs and expenses and the court costs within 90 days of the entry of the order enforcement. The board's rationale and reasoning behind their decision. There are several reasons because Mr. Henry ethical misconduct violated several rules of professional conduct, and they are listed on this slide. Pretty much RPC 1.2, which is scope of representation, RPC 1.3, which is diligence, 1.4, which is communication, 1.5, safekeeping property and funds, 3.2, expediting litigation, 8.1, bar admissions and disciplinary matters, and of course 8.4, misconduct. The mitigating factors to this case is basically that Arthur Henry never cashed the settlement check, so therefore the judge dismissed the case without prejudice. The exacerbating factors to this case is that Mr. Henry failed to communicate the offer of the settlement to his client. He also accepted a settlement offer without advising his client. And Attorney Henry did not respond to a show cause order. And this was for that case where he accepted a $5,000 settlement check that was never cashed. What the attorney could have done differently to avoid different disciplinary actions. There are several, but this is just a few here. He could have gotten something in writing from the client giving him authority to accept the settlement. or he could have made sure his client was present during all of the settlement discussions. He could also have made a moral and professional ethical decision to not take funds that was not his. That one there is the one that pretty much got to me, because he's supposed to be representing his cases. Representing his clients, not taking from them. The specific ethical rules that were broken in this particular case, and of course there were several, which I did name on a couple of slides previously, but the ones that pretty much stood out for me was RPC 1.3, which is the diligence, and that pretty much says that a lawyer shall act with reasonable diligence and promptness in representing the client. RPC 1.4, which is communication, and that particularly says that a lawyer shall promptly inform the client of any decision or circumstance with respect to which the client's informed consent, and to also keep the client reasonably informed about the status of the matter. RPC 8.4, which is the misconduct. There are two pretty much entities to this one here. And for the case 8.4b, it states that it is professional misconduct for a lawyer to commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. 8.4c is to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And that is pretty much the end of my presentation for this particular case. I thank you all for watching and also being patient with me. I was not too prepared for this, but it was very educational, and I did learn a lot pretty much from researching this case, and there are a lot of things that I had to understand about lawyer-client confidentialities and that trustworthiness between the attorney and the clients. And that's pretty much it. I don't really have an opinion to really say about this, other than the fact that with the taking money situation, I think that was the one that really got to me the most. But outside of that, I really enjoyed reading and researching this particular case here, and I really, really appreciate you all for watching and being patient with me with this. And again, thank you.